welcome to the default judgment section of the ULV Justice Center website. Glad to have you. Please note that the information provided on this site is not legal advice, but is provided for informational purposes only. If you are in need of legal advice, we advise you to consult with an attorney. With that being said, let's get started. Default judgment with written agreement. General legal information. Overview. A default judgment divorce is a judgment made by the courts because the respondent did not file a response to the plaintiff's petition. This situation is called a default with an agreement because more than 30 days have passed since you served the petition and the summons, and both of you have written an agreement about your divorce or separation, dividing your property, debt, child custody, visitation, and support issues. By this point, if you are the petitioner, you have already done the following: filled out the correct forms to file for divorce, filed your forms with the court clerk, and had the paper served to your partner or spouse. If you are the respondent, by now you have been served and you agree with the petition, but you either didn't respond in time or didn't respond at all. The next steps will be to write up an agreement, fill out your final forms, and complete your final declaration of disclosure. Writing up an agreement. In your agreement, you can both agree to end your marriage or partnership. You can also reach an agreement about how to divide your property and your debt, if anyone will pay the other spouse or partner support, and if you have children together, what child support and custody and visitation orders you would want. Make sure that you have an agreement notarized by a notary before you submit it to the courts. Also, pay close attention to what you are about to sign and make sure that you agree with everything listed or proposed in the agreement. Forms. As a petitioner of the divorce, you can request a few things for the court to consider and possibly even grant you from the respondent. This is if it isn't already covered in the agreement. If you and your spouse or partner have any children together, you can fill a form to request custody of the child and child support. You can also request spousal support from the respondent. During this process, all property and debt will be divided. Property will be divided into community and separate property. Community property is any property that was bought or received during the marriage that belongs to both spouses. For example, a dresser that was bought by the spouses during their time together. Separate property is any other property that a person owned before the relationship or marriage. For example, if one spouse owned a bicycle and the other spouse owned a canoe before their marriage or relationship. Each spouse is entitled to the property if it belonged to them before a marriage or relationship. Before you send the court any forms or documents, make sure to make copies of anything you plan on submitting. It is highly recommended that you make 2 copies of the forms and documents. After you have made your copies, 1 copy will be submitted to the court clerk, and the second copy will be sent to the respondent. Remember to keep the originals for yourself. The last thing to do is wait to receive the final judgment from the court's clerk. This will happen when the court comes to a decision after receiving all required forms and documents. The final judgment will be sent to both parties or spouses. It is highly recommended that you save this file in case you ever need it in the future. Final declaration of disclosure. You and your spouse or partner may each have to prepare and serve a final declaration of disclosure at the end of your case. You do not have to do this if both you and your spouse agree to waive it. True default. General legal information. A true default divorce is similar to the fact that spouses did not have to file a response but differ in their agreement. In a true default divorce, the spouses are not in agreement. This situation is called a true default because more than 30 days have passed since the petitioner either the spouse or partner that started the case served the petition and summons, but has not received a response from the respondent. By this point, if you are the petitioner, you have already done the following: filled out the correct forms to file for divorce, filed your forms with the court's clerk, and had the paper served to your spouse or partner. If you are the respondent, you have been served by your spouse and decided not to respond. Take caution when deciding not to respond to the summons. By not responding, you are essentially allowing the court to follow through with the petitioner's demands. If the spouses or partners have children, the petitioner can request for custody and child support of their children. The spouse may also request spousal support from the respondent. Just like in the default judgment with written agreement, example, all property and debt will be divided into community and separate property. Community property is any property bought or received in a marriage, such as furniture that the spouses or partner purchased or received while being in a relationship or marriage. Separate property is any property that was bought or received before the marriage started. For example, a car that belonged to one spouse. An inheritance also counts as separate property. After you finish filling out your desired court forms, you will have to make 2 copies of any forms you fill out. The first copy will be sent to your spouse, and the second copy will be sent to the court clerk. The last thing to do is to wait to receive the final judgment from the court clerk. This will happen when the court comes to a decision after receiving all required forms and documents. The final judgment will be sent to both spouses, and it's highly recommended to save this file in case you ever need it in the future. Summary of default judgment. Remember to write up your agreement, fill out all necessary forms, and draft a final declaration of disclosure. Please remember that the information provided is not legal advice, but is provided to familiarize you with the legal concepts, decisions, and processes that are generally experienced through a typical litigation case.